Thank you, and welcome. For those of you who don't know me, I'm Dean Korn. I'm the dean here at Gonzaga Law School. And welcome to the Quackenbush lecture. This lecture began 3 years ago in honor of Judge Justin L. Quackenbush, right there, for his many outstanding contributions as the United States District Judge. This lecture is a collaboration between Gonzaga Law School and the United States District Court for the Eastern District of Washington. We want to express our thanks to the court for their support of this lecture series, the opportunity to bring Dean Kathleen Sullivan to Gonzaga Law School, which enhances the student experience here. I'd like to acknowledge all the federal judges, including Chief Judge Peterson, Judge Quackenbush, and the rest of the federal judges. Thank you again for helping us with this lecture. I'm now going to introduce Chief Judge Rosanna Peterson, who is going to introduce Dean Sullivan. Not quite, I have to do an introduction. Time, I know. We all want to hear from Dean Sullivan. So I have a long list of her many accomplishments, and I'm going to skip all of them and say she is the Chief Judge in the Eastern District of Washington and the first woman to serve as an Article III judge in the Eastern District of Washington, but mostly we think of her as our friend and former professor here, Chief Judge Peterson.
Thank you, Dean Korn, and thanks to all of you for coming. I want to keep my introduction of Dean Sullivan short because what she says will blow you away and because it's all very important. But I do have to say just a couple of things. When I was trying to figure out how to introduce her, I couldn't figure out whether to call her Professor Sullivan because of her years as a Harvard Law professor, Dean Sullivan because of her years as being Stanford Dean Law School, or to call her Miss Kathleen Sullivan as a named partner at Quinn Emanuel Urquhart and Sullivan, LLP, a law firm that is famous for being a litigation firm that has offices in multiple cities in over 6 countries. Dean Sullivan, I'm going to choose Dean, is that okay? We're at a law school, so. Dean Sullivan has had numerous attributes listed for truly terrific, superstar, tremendously agile, and a fabulous advocate. Lawrence Tribe described her as being an extraordinary law student. And the part that really fascinates me every time I have the good fortune to hear Kathleen Sullivan speak is that she has done it all on brains, talent, hard work, I guess good looks too. But I think the brains and the talent far more than anything else. She has succeeded in academia, and she is still editing that casebook, Constitutional Law Casebook, that many of you are reading. And so she finds time to do that. She has succeeded in the courts, both as an advocate, where she argues regularly in front of the Supreme Court, and recently represented Samsung, and is noted as being one of the 100 most influential attorneys in America. But she also has succeeded with the courts in another way. One of the big treats of the Ninth Circuit Judicial Conference is when we have Kathleen Sullivan tell us about the Supreme Court update. And she does this on a regular basis, but the last one I have to recount because the air conditioning was out. There was probably 2,000 people in there. Every judge from the Ninth Circuit who could get there was there to listen to Kathleen Sullivan do a tour de force, hour and a half, no notes, Supreme Court review about everything, making it brilliant, giving us all of the background. and in 120-degree weather. So it's with great admiration and great appreciation that she would fly here from New York to give this lecture. Dean Sullivan.
Thank you, Judge Peterson, for that overly generous introduction. Judge Quackenbush, for the honor of being able to deliver a lecture acknowledging your greatness on the bench. And Dean Horn, for including me in the Gonzaga Law School community and the Spokane legal community for the day. Actually, they act as if this was planned for a long time, but I just got the call last week. They said something had happened to the basketball team. And they needed some substitute for March Madness, and so would I come? Do you know anything? Can you explain that to me? Anyway, the other reason I was so pleased to come to this part of the world is that truly one of my favorite law school teaching devices for many years in my First Amendment courses has been the all-important First Amendment case of Brockett versus Spokane Arcades, a case where I first learned to say Spokane and not Spokane, because my students from the Northwest would correct me if I erred. And it's the case that held that the overbreadth doctrine can be used to limit a law by cutting off its rotten branches, so to speak. It was a case about regulating obscenity, and the Supreme Court of the United States said, this law goes too far. It regulates speech about normal, healthy American lust, which is not subject to obscenity doctrine, and so it trimmed the law regulating certain kinds of adult entertainments. So to be here at the heart of an important First Amendment decision in Brockett versus Spokane Arcades, and I hope pronounce it correctly, I am more than honored to be here. Well, speaking of free speech, my topic for today is the Roberts Court and free speech. While the Roberts Court is often described as an incrementalist court, not one to take bold moves or make sweeping assertions of judicial power, a point that's very much on everybody's mind this week during the arguments over whether gay marriage restrictions will be invalidated in either California or the federal laws. I want to talk about an area where the Roberts Court has been bold, has been judicially assertive, has struck down a number of laws, including federal statutes, and that is the area of First Amendment law and freedom of speech. Let me just start with a few examples. The Roberts Court has held that Congress had violated the First Amendment by making it a crime to lie about one's military honors, to claim you'd won the Congressional Medal of Honor when you'd made it all up. A man called Mr. Alvarez on a water board had done such a thing, and the court overturned his conviction, saying it violated the First Amendment, U.S. versus Alvarez, 2012. The Roberts Court has also facially invalidated, under the First Amendment, a federal statute criminalizing the sale or possession of works depicting cruelty to animals, works depicting scenes in which a living animal is intentionally maimed, mutilated, tortured, wounded, or killed. That's U.S. against Stevens, 2010. The Roberts Court more recently struck down on First Amendment grounds a California law banning the sale of violent video games to minors, a law that said you can't sell to minors games in which the range of options available to a player includes killing, maiming, dismembering, or sexually assaulting an image of a human being in a depiction that appeals to a deviant or morbid interest of minors. That's Brown versus Entertainment Merchants in 2011. Fourth example, the Roberts Court has overturned as violating the Free Speech Clause a Maryland jury's $8 million award, including punitive damages, for the intentional infliction of emotional distress suffered by the grieving father of a soldier killed in Iraq at his funeral, which was picketed by the anti-gay Westboro Baptist Church, a group that specializes in sending out its particular anti-gay message at military funerals. That's Snyder versus Phelps, 2011. The court held that the First Amendment bars a jury from the standardless discretion of deciding that intentional infliction of emotional distress has been visited on someone when their speaker is speaking out on matters of public concern in a public place. And most stunningly, perhaps, and most controversial of all, the Roberts Court invalidated provisions of the Bipartisan Campaign Finance Reform Act, BICRA, commonly known as McCain-Feingold, insofar as they banned corporations from spending from their corporate treasuries to advance or defeat political candidates through independent campaign expenditures. That, of course, is the famous or infamous, depending on your perspective, Citizens United, a case whose name is not descriptive. People are citizens divided over that one. And that is because many people thought it was wrong for the court to extend the same free speech rights to corporations as to natural persons. But Citizens United didn't come out of the blue. The Roberts Court has struck down several other campaign finance restrictions as well as violations of freedom of speech. It struck down a provision of BICRA, another provision of BICRA, commonly called the Millionaires Amendment, a few years before Citizens United. That was a case called Davis against Federal Election Committee, 2008. And in that decision, the court had said you can't tell a privately funded candidate that if he spends too much of his own money, it's going to trigger freedom for the opposing candidate to raise limits on contributions that would otherwise apply. That's penalizing the exercise of speech by the privately funded candidate. And after Citizens United, the court struck down yet another campaign finance restriction, this time a state law, a provision of the Arizona Citizens Clean Elections Act, a state provision for public funding of candidates. And that provision had said, well, if you're a candidate for state office and you take public funds, but your opponent, who's privately financed, raises or spends private money above a certain amount, now Arizona will give more matching funds to the so-called clean candidate, the one who took public money. And said the court, no, that violates the First Amendment. You're in effect penalizing the candidate who becomes so popular that the other side needs more money to oppose him or her. That was Arizona Free Enterprise Club versus Bennett in 2011. Now, I could give you more examples, but I think you've seen already that in these cases, so-called conservative court, a so-called set of conservative justices, is vigorously enforcing the First Amendment. With a few exceptions, Justice Alito, for example, was the sole dissenter in Stevens, the animal cruelty video case, and Justice Thomas was the sole dissenter in Brown, the violent video games case. But most of the decisions were quite lopsided. And in some of them, involving this very unpopular kinds of speech and speakers, it was even Chief Justice Roberts who wrote the decisions for the court. He wrote Stevens and Snyder himself, the Westboro Baptist Church case and the animal cruelty video case. And in Citizens United, it was a 5-4 case, but let's look at who was in the majority and the dissent. The majority opinion, written by Justice Kennedy, was joined by Chief Justice Roberts and Justices Scalia, Thomas, and Alito, the so-called conservative members of the court, over the dissents of Justice Stevens, joined by Justices Ginsburg, Breyer, and Sotomayor, the so-called liberal members of the court. And the same majority prevailed in Davis and in Arizona Free Enterprise, the other two campaign finance cases I mentioned. So now, let's not stop there. Those are the cases where the court vindicated the free speech claim. I think that you'll see the pattern continues if we look at one of the rare cases where the court actually rejected a free speech claim. And those of you here at the law school may have heard something about this case. It's called Christian Legal Society versus Martinez. It involved a student organization at UC Hastings Law School, which is part of the public university system in California. And UC Hastings had refused to recognize with official imprimatur access to official student space on campus or access to certain student activity funds, a Christian legal society organized on the premise that to be a member, you had to ascribe to the beliefs of the organization. And under those beliefs, the organization excluded gay members. Said, we don't believe in supporting gay rights. We don't want to have gay members. And the court held, by a vote of 5-4, that UC Hastings did not violate the First Amendment rights of the Christian Legal Society when it said, I'm sorry, you can exist, you can do whatever you want privately, but you can't be a part of our student organization roster. Now let's see how that came down, and I think it will conclude my initial descriptive point that we're seeing conservatives favoring free speech rights, even where liberals sometimes do not. The majority decision here which found that UC Hastings was just limiting its own provision of a so-called limited public forum, and it was viewpoint neutral and therefore constitutional for the school to enforce its registered student organization program by limiting the use of school funds, facilities, and the law school's name and logo to only those organizations that agree they will allow, as the court put it, all comers to become members or seek leadership positions regardless of their status or beliefs. You see what that means. You can't be the campus Republican group without admitting Democrats. You have to admit anyone who wants to join. Now, the majority denying the free speech claim was, drum roll please, Justice Ginsburg, writing for the court, joined by Justices Stevens, Breyer, and Sotomayor, the so-called liberals, joined by Justice Kennedy, sometimes called liberal, sometimes called conservative. He's very much the swing vote on the court. The dissent, by contrast, that would have upheld the free speech claim was authored by Justice Alito, joined by Chief Justice Roberts and Justices Scalia and Thomas, the so-called conservative justices. What is going on here? Why are the principles of free speech being so robustly enforced by the so-called conservative justices, while in some cases the so-called liberal justices favor government regulation of speech? Has freedom of speech moved to the right of the political spectrum? After all, traditionally, freedom of speech cases over the last century, as we've developed our First Amendment law, have mostly championed the freedom of left-wing dissenters against conservative government repression. If you start back with the World War I espionage cases, and those of you who do have my casebook would be very well educated in this, but back in the World War I espionage cases, you had socialists, syndicalists, anarchists, communists, Bolshevik sympathizers speaking out and being imprisoned for their views or having their mail confiscated by the US Post Office. And in those cases, those convictions were upheld at the time, but then Justice Holmes and Justice Brandeis wrote this extraordinary free speech opinions that became the later canon, saying that that repression should not have occurred. The Red Scares of the 20s, the union movements of the 30s, the McCarthy era of the 50s, the civil rights protests of the 60s, or the Maoist flag burners who had a habit of showing up to burn flags outside such venues as the Republican National Convention back in the 80s. I think there were actually only 6 flag burners in the whole country, but they riveted the nation on the issue of flag burning for some time. It was a very small movement, but led to 2 Supreme Court cases and a debate over a constitutional amendment, consideration of a congressional statute. But you see the pattern. It's mostly left-wing dissidents being oppressed, and the free speech claim looks like it's against a conservative regime that wants to shut down left-wing protest. So why do we have the Roberts Court vindicating such robust protection for freedom of speech? Now, you might be tempted to say, well, I get it. Look who's winning these cases, or look who they think should have won. Corporations and the Christian Legal Society. Free speech for corporations and the Christian Legal Society, they're just siding with the parties they favor substantively. But that can't be right. Look at the list of other cases I just started with. The Roberts Court has also upheld the right of purveyors of violent video games, Animal Crush videos, protesters who demean military funerals, and people who demean the value of military honors by claiming wrongly that they had them. Indeed, the laws struck down in these cases might make a very good start on a Republican Party platform, right? The laws themselves, you would think, would be favored by conservatives. But conservative justices joined liberal justices there and even went farther than the liberal justices on free speech in cases like Citizens United and Christian Legal Society, where they were in the dissent. So what's happening here, my argument to you today, is that we can make sense of these patterns once we understand that we may have only one free speech clause, but we have 2 very different traditions about freedom of speech. They often overlap and produce united and sometimes lopsided results, but when they diverge, the proponents of the 2 different traditions will disagree on free speech outcomes. Let me start with the first of these traditions. I'm going to call them free speech as equality and free speech as liberty. The first tradition, free speech as equality, holds that free speech is desirable insofar as it promotes the overarching value of political equality in our democracy. The premise of democracy, after all, is that everyone should not only have equal vote, but equal voice. And on this view, the danger with governmental suppression of speech is that the voices of the powerful, including those in office, will silence or quash the voices of the relatively less powerful. And the role of free speech is to preserve a political debate that, in the words of New York Times versus Sullivan, the case that constitutionalized state libel law, is uninhibited, robust, and wide open, and therefore demands breathing room for political dissidents and those who challenge the status quo. This free speech as equality tradition helps explain many of the storied free speech opinions in our First Amendment legacy. From the time that Justice Holmes and Brandeis said we shouldn't be locking up what they called poor, puny anonymities who happened to be socialists and anarchists, through the time when the Supreme Court finally agreed with Holmes and Brandeis. It was a case that many of you know called Brandenburg versus Ohio, which finally struck down on their face those old anti-syndicalism, anti-anarchism laws that said you can't espouse the overthrow of government, you can't espouse the overthrow of capitalism. That was struck down in a case involving a Ku Klux Klan racist speaker who gathered in the woods one night and was captured on camera talking about taking revengeance on behalf of the white race and leaving a string of discriminatory epithets behind. And the court said he has freedom of speech unless he's about to incite imminent violence. Merely talking in the abstract about violence in our society doesn't count as a basis for regulating the speech. So this notion that marginal speakers, dissident speakers, the powerless, the voiceless, have a right to speak, no matter how hateful their speech may seem, comes from this notion of political equality in these cases. And on this view, suppressing the voices of dissident or marginal speakers undermines the very egalitarian premises of democracy itself. Now, to see how steeped these cases are in what you might call freedom of speech as equality, consider the language with which so many First Amendment cases in our tradition talks about a kind of anti-discrimination principle. Just as you can't discriminate on the basis of race, you can't discriminate on the basis of ideas or ideology or beliefs. In fact, that's the source of the great doctrinal point that content-based laws are subject to higher scrutiny than content-neutral laws. It's a kind of anti-discrimination principle that could fit right into our equal protection jurisprudence. But I want to point out to you that the free speech as equality tradition goes even farther than an anti-discrimination principle. A lot of our First Amendment cases embrace what you might also call affirmative action for speech. The notion that sometimes government may literally give extra support to speech than other activities, including through the use of public funds and public resources and public lands and public jobs. Now, to explain this, let's go back and remind ourselves about this origins of this notion of affirmative action for speech. It's the notion of the public forum. It gets developed in the 1930s. And there are a few repeat litigants who helped make this law. The IWW, the Wobblies, other union groups, Jehovah's Witnesses, repeat litigants who helped achieve what we take for granted now, that speech in certain public places like streets and parks is permissible, protected, can't be suppressed with the same kind of justifications as other activities like soccer games in those spaces, or I guess at Gonzaga I should say basketball games in those spaces, but maybe not this week. But the point of the public forum doctrine is, the court said for time immemorial, streets and parks have been places not just for transportation and recreation, but also for the expression of ideas in public discourse. This may seem quaint by the standards of ubiquitous digital connectivity and social media that we have today, but once upon a time it really was the case that to get together and hear from somebody you disagreed with, you might have to go hear a soapbox orator or watch a passing parade in order to do it. And the notion of these public forum cases was that parades and leafleters and soapbox orators are entitled to speak in public, and here comes the affirmative action for speech part, even though other users can't claim the same entitlement, and even though this public forum speech imposes significant public costs borne by the taxpayer. How so? The costs of the barriers you have to put up for crowd control, the cost of the police who have to redirect the traffic around the parade or stop hecklers' vetoes by hostile audiences from becoming fisticuffs that lead to riots, or the sanitation workers who have to come and pick up all the leaflets on which these glorious free speech thoughts have been expressed. Now, the court just assumed without discussion that the First Amendment imposed that implicit cost on the public as a privilege for speech in the public forum. That this is in effect a First Amendment compelled subsidy doctrine, the public forum doctrine. Now, part of the idea was redistributive. And you see this not only in the public forum cases, but in a series of early free speech cases developed in the 30s and forward, involving First Amendment invalidation of bans on certain low-cost media. In those days, leafleting, handbilling, door-to-door canvassing, sound trucks. You know the old expression, A.J. Liebling, freedom of the press belongs to them who owns one. The counter is that if you don't have access to private newspapers or your own broadcasting network, you needed to have access to the public forum or to handbilling, leafleting, door-to-door canvassing, or sound trucks in order to get your message across. And to summarize that entire set of cases, public forum and all the invalidation of low-cost media bans, I think it can be summed up in a great line that Justice Black wrote in a case called Martin versus Struthers, which invalidated a door-to-door canvassing law, banning going door-to-door and trying to hand people your leaflets. He said, this law violates the First Amendment, which in part is designed to protect the poorly financed causes of little people. The poorly financed causes of little people, people without the resources to express themselves through privately owned media. Now, so far I've said that there's an equality principle that says anti-discrimination, no discrimination against ideas. There's an equality principle that says affirmative action for speech. You have to spend a certain amount of public resources as an incident of the cost of the First Amendment. And further, so-called affirmative action for speech arises in the free speech equality tradition under the so-called unconstitutional conditions line of cases. These cases have held that sometimes government must, in effect, subsidize speech, even if it doesn't like it, by being even-handed in the distribution of public jobs or public funds to speakers. The idea here is that a denial of a privilege that the government need not give you at all can sometimes nonetheless be unconstitutional because it discriminates. If it is, if the funds or job is given to you or taken away from you on the basis of your speech. So I'll give you a few examples from the origins of this doctrine. It was mostly a bunch of Justice Brennan opinions. A veteran may not be denied a tax credit during the McCarthy era for refusing to sign a loyalty oath. And you say, well, he didn't have to get the tax credit at all, but the court said you can't deny this privilege on the basis that you may be discriminating against this person's ideology. In a later case, the Warren court held that a public school teacher may not be fired for criticizing the school budget, saying too much was spent on sports and not enough on academics. A later case called League of Women Voters versus FCC held that a public broadcasting station may not be refused federal funds from the Corporation from Public Broadcasting merely because it engages in editorializing. That deprivation of funding is a form of penalty on freedom of speech, even though no one needed to give you that money in the first place. In a later case called Velasquez involving legal aid attorneys, again continued this unconstitutional conditions line by holding that legal aid attorneys cannot be denied their federal funding merely because in representing their clients, they challenge the laws under which the cases are being litigated, rather than just representing their clients under those laws. The majority of the court said that's interfering with the freedom of speech of the lawyer. The lawyer has to be able to do whatever his or her professional duty is to the client, and this inhibits freedom of speech within the litigation. Now, these unconstitutional conditions cases were mostly pioneered by the so-called liberal justices of the Warren Court, most notably, as I mentioned, Justice Brennan. Now, this compelled subsidy branch of freedom of speech has been controversial. Let me cite a couple of the greatest opponents of this idea that your freedom of speech can be abridged by somebody taking away a privilege they never had to give you in the first place. The most famous curmudgeon on the subject was the great Justice Oliver Wendell Holmes, back when he was sitting on the Supreme Judicial Court of Massachusetts. When people challenged their denial of speech rights on the Boston Common, he wrote that no one has any more right to speak on the Boston Common than they would have to trespass on a private homeowner that didn't want to invite them in to talk. In a later case called McAuliffe, he upheld the firing of a garrulous Irish Boston policeman, is there any other kind, who had gone around talking about politics during working hours, and this violated a kind of rule against politicking on the job. And Justice Holmes said there was no problem with that because, and this is a great line, a policeman may have a right to talk politics, but he has no right to be a policeman. Now, latter-day counterparts of Justice Holmes in this opposition to the unconstitutional conditions line would include Chief Justice Rehnquist, the late great Chief Justice Rehnquist, who dissented in that public broadcasting case I mentioned, League of Women Voters. He said, I read the Brennan opinion, and it's as if he viewed government as the big bad wolf who had taken food from Little Red Riding Hood while neglecting to say that the big bad wolf had provided the picnic basket. Right? And he later spoke for the majority in Rust versus Sullivan, a case that held there was no First Amendment violation in conditioning funds for family planning on the agreement of the recipient not to encourage, counsel, or advocate abortion. Family planning clinic said that's a violation of our First Amendment rights. The court said, no, it isn't. You didn't have any entitlement to that money in the first place. And government can do more with carrots than it can with sticks. It can try to influence through the provision of funding that you'll speak in favor of carrying the pregnancy to term. We're not suppressing anybody's speech out in the private sector, said the court. And writing for the court this time, then Justice Rehnquist said, just because the government funds the National Endowment for Democracy does not mean that it must fund the national endowments for communism or fascism too. Now, outdoing Justice Holmes and even Chief Justice Rehnquist for colorful language on this subject, let me remind you of Justice Scalia's view on the matter. Justice Scalia is almost always more colorful than anybody else that you can just describe. And there was a case called Finley versus National Endowment for the Arts. Does anybody remember the great performance art debates? There were debates about whether a publicly funded art subsidy could go to performance artists who wanted to perform works that many people would consider obscene or scatological. Or in one of the most controversial issues, whether a blasphemous depiction, a depiction of a crucifix in a beaker of urine, Andre Serrano's supposed piss Christ. Should public money go to fund that kind of art, or can the government say, no, if you're going to get a National Endowment for the Arts subsidy, you have to have art that, and the language of the statute as it was challenged was, art that bears in mind the traditions of decency held by the American people. Now, if you said nobody can speak unless they follow the traditions of decency of the American people, or you'll be thrown in jail, obviously that would violate the First Amendment. But in the court's view in NEA versus Finley, merely trying to induce decency through carrots is very different from trying to punish indecency with sticks, and the law was upheld. Justice Scalia thought it wasn't upheld vigorously enough, so he concurred. And he said these performance artists are entirely free to épater les bourgeois. They are merely deprived of the additional satisfaction of having the bourgeoisie taxed to pay for it. That's his view. Now, bear those cases in mind when we come back to Christian Legal Society against Martinez. I've tried to establish that the free speech is a quality tradition, looks to anti-discrimination principles, and also a kind of affirmative action for speech. You have to fund speech even when you do not like it. You have to pay for speech even when it costs. We're going to promote speech over other values in our society through the public forum type cases and the unconstitutional conditions type cases. Now let's turn to the second tradition, a competing tradition that runs through and justifies many of our great free speech cases. And I want to call this free speech as liberty. On this view, the most important function of free speech is not to equalize speaking power in a democracy by ensuring breathing room for dissidents or the poorly financed causes of little people. Rather, to the libertarian free speech advocate, the most important function of freedom of speech is to protect us from government tyranny, from the overbearing and potentially tyrannical force of government that might restrict speech to entrench itself, to let the ins keep the ins in and the outs out, so to speak, to clog the channels of political change. Now, to those who value liberty as paramount, government will always be suspect as likely to suppress speech that could undermine the incumbent regime. It's a little bit like putting the fox in charge of the chicken coop to let Congress regulate speech on this view. Government will always have hydraulic pressure to overregulate, and incumbents will always have strong self-interest in keeping other people out. Now, on this libertarian view, for speech as for many other libertarian values, you generally think that social decisions are best made by individuals through decentralized social mechanisms, through markets, including the marketplace of ideas. And here, free speech is no different from other libertarian views. Lochner may be dead, the notion that there are limits on government's ability to regulate wages and hours and other economic liberties. But we have a kind of mini version of Lochner under the free speech clause when we protect commercial speech on the view that you shouldn't protect consumers from making their own decisions about buying the branded versus the prescription drug. Now, this free speech as liberty strand is present in many of the traditional free speech decisions and opinions, including some we've already mentioned. I'm not suggesting that one opinion can't have both egalitarian and libertarian language. I'm setting this up because we're going to see that even though they sometimes overlap, they sometimes diverge. But probably the most ringing expression of the libertarian version of our free speech tradition is the great case of West Virginia against Barnett, the second flag salute case, which, while World War II was still ongoing, the Supreme Court held that public schools could not compel children to salute the flag if their families, for instance, Jehovah's Witness families, didn't think they should be worshiping graven images. They had a conscientious objection to saluting the flag. The court first said it was okay, then reversed itself in Barnett and said that's a First Amendment violation. And the famous line from Justice Jackson in one of the opinions in the case is that if there is one fixed star in the constellation of our liberties, it is that there is no government orthodoxy in the realm of ideas, drawing a pointed contrast, very vivid at the time, with the fascist regimes against whom we were fighting World War II. Many of the cases protecting dissidents echo both the you have to protect the poorly financed causes of little people language and the you shouldn't have government orthodoxy language. But I want to suggest that the anti-orthodoxy approach is conceptually different from the redistributive approach to speech. Now, I've talked so far about the similarities between egalitarian and libertarian. Now let's talk about the differences. When it comes to public forums and unconstitutional conditions, libertarians might very much, you'd think, part company with egalitarians. On the libertarian view, freedom of speech is a vehicle for facilitating the private beliefs that we already hold in our decentralized marketplace of ideas. There's no right to government subsidies for speech on this view. You may have a right to talk politics, but you don't have a right to be a policeman. He who takes the king's shilling is the king's man. He who pays the piper calls the tune. On this view, you would expect a libertarian free speech advocate to reject public forum and unconstitutional conditions cases. You would expect the libertarian view to overlap the anti-discrimination view of the free speech as equality folks, but not necessarily the pro-subsidy view. And conversely, you might expect the free speech as equality folks to agree with libertarians when speech restrictions harm the poorly financed causes of little people, but to go the other way when free speech is serving the well-financed causes of big people, to go the other way when it is government regulation that is restricting speech to advance equality by turning those voices down. If you think equality is paramount, you're for speech when it serves equality, but you're for regulation of speech when it serves equality, and you're not going to be consistent in those views. Now, with that background, Free speech is equality, free speech is liberty. Let's return to our topic for today, the free speech decisions of the Roberts Court. And as we now can see, the two sometimes diverging free speech traditions can explain Citizens United perfectly. The majority opinion by Justice Kennedy expresses a libertarian conception of free speech that focuses on the freedom of private speech from government control to prevent government tyranny and entrenchment. On this view, what matters is that the First Amendment says Congress shall make no law abridging the freedom of speech. It doesn't speak about speakers or who gets to have those rights. It's about a system in which free speech is a counter to government entrenchment. And the important point is that speech be free whatever its source, including the speech of private corporations. The majority opinion, authored by Justice Kennedy, perceived the danger of government overreaching and tyranny as especially acute in the restriction on corporate support of independent ads, because the legislative history was all about incumbent congresspeople saying we have to get rid of these terrible attack ads. And writing for the court, Justice Kennedy said that the fact that the incumbent government is trying to limit the speech of potential challengers proves his point. Tyranny is the danger here. On this view, government is not allowed to interfere to make our collective discourse more balanced or enlightened. If corporate funding helps to promote attack ads, and they're negative and unseemly, it's up to the citizens to decide to reject them, not up to the government. The government, so to speak, can't be like a great democratic DJ who can come in and mix the sound to make sure we've got the right voices competing. Now, contrast that with the dissent authored by Justice Stevens. Perfectly expresses the free speech as equality view. It suggests that free speech is for natural persons, not corporations, that corporations, with the benefit of their resources and privileges from the corporate form, threaten to drown out other voices, and that government should be free to prevent the distortion of political dialogue and the drowning out by the powerful voices of the small voices. And unlike the case of restrictions of speech, here the regulation of speech, in Justice Stevens' view, promoted equality. He's against restrictions of speech that harm equality, but here for a regulation of speech that promotes equality. And for those who see free speech as protectable only when it furthers equality, this time they sided with the regulation and not the speech. Now, the same theory helps explain why, perfectly, why the so-called liberal justices plus Justice Kennedy voted with the UC Hastings Law School and against the Christian Legal Society in the Martinez case. Here, Justice Ginsburg, writing for the court, suggested that UC Hastings Law School had a permissible, viewpoint-neutral purpose because it was restricting speech to promote equality. As Justice Ginsburg noted, the exclusion of CLS under the all-comers rule promoted the law school's non-discrimination policy and helped promote tolerance in a diverse student body. And she said these are viewpoint-neutral goals. They don't inhibit freedom of speech. So far, so good. But let's look at what else Justice Ginsburg had to say in that opinion. And I hope by now this will at least seem a little bit surprising. She went further and she said the lesser First Amendment scrutiny that applied to UC Hastings was because UC Hastings was merely dangling the carrot of subsidy, not wielding the stick of prohibition. That's Justice Ruth Bader Ginsburg, often called a liberal justice, channeling Chief Justice Rehnquist. She's saying exactly what Chief Justice Rehnquist said in the Big Bad Wolf quote. It's just the carrot of a subsidy, not the stick of prohibition. And now Justice Ginsburg here, in other cases, I don't want to overstate it, thinks there should be an unconstitutional conditions doctrine, just not here. Now, on her view, and this was the view of Justice Holmes and the view of Chief Justice Rehnquist and of Justice Scalia, on her view, the government is allowed to have its own point of view. That sexual orientation should not be a basis for discrimination, and it's allowed to enforce that view against speakers that would mar that message when they are part of a government program. And she's not alone in this kind of liberal deviation from the unconstitutional conditions line. Justice Kagan took a similar view in dissent from one of the campaign finance cases, that clean election case I described to you from Arizona. She dissented, saying, the government here is just trying to use public money to influence, to shore up the clean candidate against the dirty candidate, the candidate who's spending his own private money. And she wrote in her dissent, Justice Kagan did, that our court has often distinguished between speech restrictions and speech subsidies. These are liberal justices, but they sound just like Rehnquist and Scalia. They're distinguishing between carrots and sticks. Why? Because in both cases, equality was the value that dominated the speech analysis for Justices Ginsburg and Kagan, and where a speech restriction promotes equality, speech loses out to the equalizing restriction. Now that much is understandable, but why on earth do we now find the so-called conservative justices, who in other cases have agreed with the Holmes, Rehnquist, Scalia view, why do we find them saying that conditions on government benefits can be just as unconstitutional as regulations of speech? Why do we find conservative justices saying government may not do more with carrots than it may do with sticks? Well, I think the answer is that correctly understood, unconstitutional conditions, which I described to you as coming out of equality notions, has a liberty dimension as well. I think the answer is that the libertarian justices are now appreciating that in the contexts as diverse as campaign finance or university diversity policies, there is a reason to have First Amendment enforcement against the distribution of privileges, like membership in the official student organization roster, or the receipt of public funds. To understand that, you have to realize that the more monopoly power government has, the more a condition on a benefit operates just the same as a regulation. A great example from another context to make this point is then Justice Rehnquist's opinion in a pre-Casey abortion regulation case called Webster. One of the issues in that case was, could a state bar the use of public hospitals for the performance of abortions if there was conscientious objection by the taxpayers of the district? And the court said there, yes, but Justice Rehnquist said it would be different if we had a national health service. That is, if the only hospitals you could go to were publicly funded. If there was no private sector, if there were no private hospitals to compete with Catholic hospitals and public hospitals, if there was nowhere you could go in a jurisdiction for an abortion from a private vendor, then it would be different, he said. And his point there was that there was if the more monopolistic power government has, the more a limitation on government funding looks just like a regulation. They become the same thing. Now, I think the intuition in Christian legal society among the conservative dissenters was that a public university has a little bit of monopoly power too. Sure, there are private substitutes, but they cost a lot more. And somehow by effectively coercing tolerance of gay people, UC Hastings was enforcing a kind of liberal orthodoxy of ideas. No less than West Virginia was enforcing a patriotic or conservative orthodox of ideas by making Jehovah's Witnesses salute the flag. And on the libertarian view, the idea of a government message, the idea that government has more power to restrict speech to uphold its own message, is very disturbing. It sounds uncomfortably totalitarian. It sounds like the opposite of Barnett. Now, I'll just refer briefly to another context where we recently saw the conservative justices embrace a kind of unconstitutional conditions doctrine. You may recall we had a little debate about the Affordable Health Care Act a little while ago, a little bit of a Donnybrook over that. It was a very complicated decision, but one of the least noted parts of it was that the court struck down a condition on the states of receiving Medicaid expansion funds. The court held that it was an unconstitutional condition on the states, who should be able to make their own policy, to tell them you can't have any Medicaid if you don't embrace the Medicaid expansion. The Medicaid expansion would give Medicaid to a lot more of the population than the previous state law had allowed. Now, the states are all, it turns out, opting in now, but the court held that they had a right not to opt in. And this was Chief Justice Roberts channeling Justice Brennan, not his old boss, Chief Justice Rehnquist, when he said that a denial of Medicaid funds can be so effectively coercive, it operates just like a fine. So we have Justice Ginsburg channeling Chief Justice Rehnquist. We have Chief Justice Roberts channeling Justice Brennan. What is going on here? It's the two competing notions of freedom of speech, equality versus liberty, and the liberty idea is now driving some of these unconstitutional conditions rulings. Now, to summarize, the Roberts Court has been surprisingly robust in upholding free speech claims, including for highly unpopular speakers and on highly controversial premises, like corporations have speech rights. This is understandable once the libertarian roots of our free speech traditions are analyzed alongside the egalitarian ones. I want to close by saying I don't want to overstate the matter. There are some qualifications here. First, the Roberts Court has upheld some restrictions on freedom of speech. Cite to you, just as a recent example, Holder versus Humanitarian Law Project, which upheld a federal law that criminalizes knowingly providing material support or resources to a foreign terrorist organization, even as applied to the protected speech activities of the foreign organization as opposed to any material violence. And that was a lopsided opinion, and Chief Justice Roberts wrote for the court. And he even said that the law was upheld under so-called strict scrutiny. So it was a real big rejection of the First Amendment claim. Second, some members of the Roberts Court are not free speech absolutists. They take what they call explicitly a kind of balancing approach to freedom of speech. For example, in the Stolen Valor Act case, Alvarez, you had a separate concurrence by Justice Breyer and Justice Kagan. They concurred only in the judgment because Justice Kennedy, for the plurality, had applied strict scrutiny, said this law interferes with ideas. It may be a false statement of fact, but even false statements may be protected for breathing room. They said, no, they would apply intermediate scrutiny because this is not restricting false statements about philosophy, religion, history, or the social sciences. It's rather restricting speech about easily verifiable facts that do not concern such broad subject matters and that are less likely than true factual statements to make a valuable contribution to the marketplace of ideas. Oh my. That's two justices of the court saying we can decide that speech has more or less value to the marketplace of ideas. That's very unusual in our tradition. Our tradition, our extravagant free speech tradition, usually says we treat all speech as to be evaluated in the eye of the beholder or the listener, not by a court. Although we've seen some other deviations from that, I want to acknowledge the passing of the very great journalist and author of First Amendment materials, Anthony Lewis, who wrote for the New York Times for many years, wrote Gideon's Trumpet, and wrote a book called Make No Law about the New York Times versus Sullivan case. He was a dear friend and a great man. But toward the end of his days, having been a First Amendment absolutist his whole life, Anthony Lewis thought maybe you could balance speech sometime. And he thought that maybe Judge Tatel was right in saying sometimes you could compel authors to divulge their sources. If the government interest is important enough and the speech value isn't that great. But it's unusual. It's unusual. And so, but I want to acknowledge that first, the court has upheld some restrictions on freedom of speech. Second, some of the moderate liberal members of the court want to start balancing speech issues more. And third, I want to note that one member of the court, Justice Alito, has taken a strong view that departs from free speech absolutism. He is the one justice who's taken the view, albeit in dissent, that some speech is just beyond the pale. It can be excluded categorically from free speech protection. He thinks crush videos and lies about military medals and your own valor and military pickets by the Westboro Baptist Church are all beyond the pale of free speech protection. I think his view can be described as a kind of Burkean conservatism in the sense of Edmund Burke. His view is that the kind of speech we allow in our society affects the tone and tenor of our society. It affects our values. It affects the fabric under which we live. And therefore, you shouldn't be limited to regulating speech only when it's going to bring about imminent material harm. Well, there was once a judge who took that view. He took it before the Senate in 1986. It was Robert Bork, and he lost the nomination of President Reagan in part over expressing that view of freedom of speech, that some speech is beyond the pale and shouldn't be protected. But it's not an unusual view in the rest of the world. Consider the laws that France and Germany have against genocidal speech or Nazi memorabilia being purveyed. Consider the laws that the UK has against glorifying terrorism. It would fail our Brandenburg test in the United States, and yes, the UK has criminalized and deported speakers who, in their view, glorify terrorism. And just to put the point a little bit, if I could tell you an anecdote to try to bring this point home about just how extravagant our free speech tradition is compared with that of other industrial democracies like our counterparts in Europe. I had the privilege of going to a conference some years ago with the late, great Ronald Dworkin and with a number of judges from around the world, and we were discussing the regulation of hate speech. And of course, in our First Amendment tradition, we allow a great deal of speech, even the speech of neo-Nazi marchers in brown shirt and goose step through Skokie, Illinois, through a Jewish neighborhood predominantly inhabited by Holocaust survivors. How much more extravagant a protection of freedom of speech could we have than that? Now, at this conference, which included judges from France and Germany and Australia and Hungary and Ireland and all around the world, Israel, South Africa, a French judge from the Conseil Constitutionnel addressed the body in stentorian tones, and he said, "We in France cannot believe that you Americans let the Nazis walk through your streets." At which point the Americans are looking at the Brits and the Australians thinking, gee, we wish the French had thought of that sooner. True story. But I do want to suggest, with all that Justice Badinter was making these remarks, and Justice Alito takes this position today, it's only our American tradition that thinks that all speech is presumptively protected and none of it can be categorically excluded except when it causes material harm. It's an unusual view in the rest of the world, and countries that are more of a tinderbox than we are in our blissfully post-war life, South Africa, Israel, have to worry about speech causing potential violence long before it causes actual violence. So that's the three qualifications. We have Justice Alito expressing the Burkean Borkian view. We have Breyer and Kagan going a little mezzo-mezzo on the balancing of speech. And we have some cases where even Chief Justice Roberts says, sorry, terrorism exception here. As to the seeming contradictions we have explored today, and here I close, you might be wondering, should I be worried, especially if I'm a law student learning about the rule of law, that it looked like Justice Ginsburg was channeling Rehnquist and Chief Justice Roberts was channeling Brennan, and are these contradictions? Should I worry that some justices would strike down unconstitutional conditions on the speech of abortion clinics, but not that on the Christian Legal Society, or vice versa? And my final message to you is no, you shouldn't worry. I see this as more positive than negative. After all, our Constitution created an institutional design and a set of rights that were designed to ensure that constitutional principles are never the exclusive property of any one view or faction in our society. And as free speech in the Roberts Court demonstrates, they have not been. Thank you.
Thank you so much, Dean Sullivan. I don't know if we're going to have time for questions. I know some of you probably have them, but I do want to give Chief Judge Peterson a moment to introduce Judge Quackenbush, in whose honor this lecture is.
Perfect.
Sure.
Yes, I'm happy to.
Yeah.
Why don't you speak about Judge Quackenbush?
That'd be fine with me.
We're going to usurp the law school timing a little bit, just to offer you an opportunity. Dean Sullivan has agreed to take some questions. We have a limited amount of time. Any questions?
Maybe two questions? Yeah, up there?
Yeah. I was wondering if you think the Roberts Court, after affirming First Amendment rights for corporations, if you think that they would apply liability to corporations for human rights abuses abroad in the Kiobel case that's been
So the question is, would the Roberts Court, having upheld free speech rights for corporations in in Citizens United, would apply responsibilities to corporations in the pending case called Kiobel against Royal Dutch Petroleum? And the question is directed at me because I've argued the case twice now for Royal Dutch Petroleum. I am fervently opposed to corporations committing human rights abuses, and we have a million mechanisms for stopping human rights abuses throughout the world that are the outgrowth of Nuremberg, one of the greatest accomplishments of international public law in the 20th century. The only issue in the Kiobel case is whether the Alien Tort Statute, which was passed by the first Congress in 1789, was designed to be a mechanism to bring private suits into American courts to solve those human rights abuses. I think based on the scholarship, it was not, that the purpose of the Alien Tort Statute was to enable people like the French ambassador, when he was bopped on the bean in Philadelphia, to go to federal court to sue over it. It was about assault on aliens within our own jurisdiction. Congress could amend and has amended our laws to provide for punishing people for human rights abuses. It passed the Torture Victim Protection Act, but it expressly limited it to individuals and not to entities, as the court most recently held. So I think the answer is no particular holding has application necessarily outside that holding. I do think that the freedom of speech protects corporations because it is about the freedom of speech. I think the Alien Tort Statute was not designed to punish corporations, but that doesn't mean that there aren't all kinds of mechanisms Congress could use, but has chosen not to go after corporate human rights violations abroad. Thank you for the question. One more from anyone? Yes, I'm sorry.
I was curious about your thoughts on the court holding religion to be inclusive of non-believing religions, such as atheism, and how it will begin to depend on the freedom of speech rights of religious people.
Okay, so the question is, does the court's definition of religion to include non-religions or atheism and agnosticism, is that an interpretation of the religion clauses that could actually ultimately harm religious groups? And I know where you're coming from. If you're protecting the rights of atheists and agnostics to exclude certain things, say, from a public school curriculum, won't you be inhibiting the rights of religious people to be part of that curriculum? So this is a deep question. We don't have time for it here. I think the court is, but I'll just say just briefly, I think that I think the court has to hold that the framers' decision not to have an established church protects us against government coercing us into religion as much as coercing us out of religion. That the freedom of the free exercise of religion coupled with the Establishment Clause has to have an application both to coercion into a religion or coercion out of it. So I think we're stuck with that. There have to be moments, though, when we say that the balance between different religious groups may sometimes allow some kinds of religious expression in public squares, and we sometimes have allowed that. We've allowed public symbols in public squares, or the court has allowed public symbols in public squares, sometimes where it's not thought to connote an official coercive message. You may remember the Ten Commandments cases from a few years ago when the court upheld the placement of a big, giant Cecil B. DeMille slab with the Ten Commandments out on the lawn outside the Texas Capitol in Austin, when it was part of a Liberty Park that had a lot of other monuments too. But at the same time, it struck down the posting of the Ten Commandments in a Kentucky courthouse where it was on the wall and it looked like the court was subscribing to the Ten Commandments inside the seat of government power. And that's an illustration of how the court is going to see the balance of diverse religious views differently depending on the context. And they said, Texas had a different purpose here. It was celebrating liberty. You didn't know that Moses had come to Texas, but you know, it is very big. And that was the sort of notion there. So I think the court is struggling with that question, but I'm very concerned that we're keeping people from class, Dean.
Well, we can hold off on that.
Now the students say, let's have some more questions.
No, we said classes would go to at 1:15, but we need the students who are going to get their lunches. But I'd like Dean.
I think the most important thing is that we
Yeah.
say a few words about Judge Quackenbush. I want to thank you very much for being such an attentive audience. Thank you very much.
Dean Sullivan, I know that your comments are inspiring thoughts in my mind, and I know they're going to inspire a lot of conversations and thoughts in everyone else's. Thank you so much. Certainly, I want to introduce Judge Quackenbush, for whom this lecture series has been organized. Judge Quackenbush was nominated by President Carter in 1980 to serve on the federal bench. We've been extremely fortunate to have Judge Quackenbush as the preeminent member of our bench for 33 years. Judge Quackenbush.
Dean Sullivan, thank you very much. I've had the benefit of your presentations to the Judicial Conference, Ninth Circuit conferences for many years, and tonight and this afternoon was as good as any I've heard, and thank you very much. I might say to the question about the Establishment Clause, and it's my prerogative, I'm not going to invade Dean Sullivan's area, but I believe yesterday the Supreme Court came down with the City of Lancaster and rejected challenges to the City of Lancaster, California, having invocations prior to their city council meetings. I commend the reading, a unanimous decision. I often say at judges' meetings that my role in the court, the most important role that I have in the court now is historian. This is the 100th anniversary of Gonzaga Law School. And my family has had an association with Gonzaga University Law School for 83 of those 100 years. And that association involved Ralph Foley, the Ralph Foley Library, and my father, both working days. My father as a football coach, Judge Foley at a service station in Hilliard, attending law school 83 years ago. And that tradition, of course, is followed because my father then instructed here. I attended here and instructed here. And this association is something that I treasure. The most important part of this afternoon is Judge Imbronio. She was my first law clerk, a graduate of Gonzaga University. And we judges, Judge Nielsen and I, Judge McNichols, Judge Van Sickle, and Judge McDonald in 1991 made the best decision we ever made by appointing Judge Imbronio as our magistrate judge here in Spokane. She's retiring. There are those who say to me, Judge Imbronio is retiring? But I think that we owe a great deal of thanks to Judge Imbronio for her work. The volume that she handles is unbelievable, and she handles it with dignity and fairness, and Cindy, I thank you. Thank you all.
Thank you, Judge Quackenbush, Magistrate Imbronio, the rest of the federal judges, Dean Sullivan, Chief Judge Peterson, and now students go to class. Thank you very much.